can't handle that concept either. Do we have a congressional minute? We got anything real quick? A whole lot of nothing. Wonderful. Great. Let's just move on in life then. Right? A whole lot of apathy this morning. Okay. So listen, we're talking about judicial activism. Do we know what that term means? Hey, by the way, is this a positive or a negative term? How many of you think judicial activism is bad? Zane. Trent. 2. How many of you think judicial activism is good?
Wait, was the first one bad?
Yeah, the first one was bad.
I require more information.
How many of you have no clue what judicial activism is, and therefore you're reserving your opinion until after this lecture? Fair enough. All right. So, judicial activism is sort of juxtaposed with the concept or the idea of judicial restraint. Okay? Activism is basically this philosophy, this idea that the court should take an active role, hence the term activism, in sort of righting the wrongs of society. All right? In this instance, generally what you get with an activist approach is you tend to get a more fluid interpretation of the Constitution. Right? We know what I mean when I say that? The Constitution can change. It's that living Constitution ideology versus the strict constitutionalist ideology that we talked about a while ago. All right? So with judicial activism, the courts exist there as sort of guardians to protect against sort of the negative and the ill aspects of life. All right? There are a variety of examples of what are deemed to be judicial activism. Anything from requiring legal aid for poor people, modernization of prisons. These are all sort of judicial activist type roles, right? So when we take this idea here, like requiring a modernization of prisons, how's that judicial activism? Right? And this is sort of what you need to understand. Are prisons unconstitutional? No. If you break the law, you go to jail. Right? If you break a serious enough law, you go to prison. There is a difference. I hope you never have to figure out the difference. All right? But if a court says that the conditions within a prison are cruel and unusual punishment because the prison is whatever, right? It's overcrowded, right? So you've got like 5 people to a small little cell, right? Maybe that's cruel and unusual punishment, right? Or you've got, dilapidated buildings that are falling apart, like whatever it is. If you say basically like, and this is how it gets into activism, because the court will come out and say like, the concept of prison is not unconstitutional, but you have to modernize it and make it, meet some sort of standard of living, and then it's acceptable, right? Now the court is sort of dictating to the country what it has to do. That's that idea of judicial activism. Does that make sense? All right? And so all of these are just various examples. Understand, when we go down here to the bottom, I'll go back to this, right? Striking down Gun-Free School Zones Act. Understand that not all judicial activism is necessarily liberal in its nature, right? We tend to think of judicial activism as a liberal term. It's not always liberal, all right?
Like striking down that act, isn't that part of what they do? Like they check the legislative branch's laws that are unconstitutional.
But why is that unconstitutional?
Because
why can the Department of Education not have a stipulation that says guns aren't allowed in schools?
Because when they interpreted it, that violated the Second Amendment.
No, it doesn't. The Second Amendment says you have a right to own a gun. It doesn't specify where you can take said gun. It just says you can own it.
The
court shouldn't be deciding that. That's for the legislative branch.
And the legislative branch decided that you can't take it to a school. And then the court said, nope, you can't do that. And that's what makes it judicial activism, right? But that's more of a conservative philosophy of judicial act. Like, that's a conservative judgment from the court, right? You want to bring a gun to school, go ahead. Don't bring a gun to school. Okay? The state of Texas is not okay with that. All right? But it's not a federal issue anymore. But you realize how that's a conservative lean on judicial activism, right? Because as Zane just said, it should be up to the legislature. Well, the legislature made its decision and the court said no. All right? So don't think that this is just something that happens on the liberal end. All right? And, again, you want to go down here, right? No death penalties for the mentally retarded. And that's judicial activism. Because one, the national government is now setting some sort of standard as to what is or is not mentally retarded. And in fact, there's a guy in Texas who's currently appealing an execution because he might be mentally handicapped. They've given him multiple basic IQ tests. One of them he got a 55 on, right? Which some people are arguing actually proves that he's really intelligent because he intentionally got the wrong answers because he realized that if his IQ was low enough, they couldn't kill him. Which I would argue makes you not mentally retarded. Like, if you're smart enough to figure that concept out, probably not retarded. I'm just saying, that's my thought. I'm also not a doctor, so I have no idea what constitutes mental retardation. Alright? So, here's sort of the opposite. And the opposite is this idea of judicial restraint. Right? And judicial restraint is basically the philosophy or the ideology. The courts should be basically doing as little as humanly possible in terms of establishing law or precedent or whatever. Right? Sometimes with judicial activism, there's another term that you might hear. It's actually a little bit more common a term in common usage today. Right? And that's the term legislating from the bench. Have you heard that term? Some of you, yes. Okay? That's the idea of judicial activism, right? And so judicial restraint is the opposite. You don't want to create some sort of precedent or standard or rule or law or whatever, right? So with restraint, it's merely an interpretation. All right? And basically the idea here with judicial restraint is that it's ultimately the responsibility of the President and Congress to be the guardian of the people and to do things that are in the best interest of the people. In fact, much earlier in the semester, you watched a little video in which Justices Behr and Scalia were they're having a discussion with one another, right? You remember that? And Scalia, if you haven't figured it out yet, was very much a strict constitutionalist, right? Scalia is the type of guy that believes wholeheartedly in judicial restraint. And he made the argument that it's not the job of the court to enact change, and that change can happen just as fast as anybody wants it to, so long as you have Congress and a ballot box, right? That Congress can change whatever it wants as quickly as it wants, right? And you don't need the court to do it. Which is a fair argument. Obviously, we know at this point that Congress is wildly inefficient, and they should be wildly inefficient. I don't want an efficient Congress. I really don't. All right? Because I don't need a Congress that creates all sorts of just ridiculous laws. All right? And so with judicial restraint, you'll even see instances or times where members of the court who are just adamantly invested in this ideology, they'll actually try to not take cases whatsoever. They don't want the court involved because they don't even see it as a federal issue, right? They see the responsibility of the court as something just dealing with constitutional questions, all right? with this, this idea of judicial restraint, you will generally see the ideology of original intent applied as well. Right? And that sometimes gets a little dicey because it's sometimes difficult. I'm not going to say it's impossible, but it's sometimes difficult to determine what the intent is constitutionally when the law pertains to GPS tracking on automobiles, right? Or possible surveillance of radio waves, right? Because if you've got two people communicating via radio and you just happen to pick up that frequency and you hear what they're talking about, is that surveillance? Would that violate the Fourth Amendment if you heard something?
You make that argument.
How many of you think that it does violate the Fourth Amendment?
It couldn't be used in a court of law.
A couple of you do. How many of you think that it doesn't violate the Fourth Amendment? Right? There's going to be a couple of you that would agree with that as well. I think both of you are right. And again, it's part of the reason why I love the court so much and why I'm such a fan, or why this is what I really thoroughly enjoy about this class, is that neither of those are wrong. Right? You can very easily make the argument that the gathering of information in that regard without a warrant makes it inadmissible. Right? You can just as easily make the argument that that information is presented in public now over an open channel, and therefore it's not subject to some sort of warrant. Right? And if I'm walking down the hall and I never remember her name. Who's the SRO here? You know what I'm talking about? The officer on campus.
Okay.
I forget her
The
name.
security guard or like the
No, the actual police officer, the actual Rosenberg police officer that's on campus. Right? I mean, if she hears me, as I'm walking down the hall talking about something that I did that's illegal, right? Could she use that against me? Yes.
Why she didn't catch you in the she doesn't have like evidence or whatever.
But that is evidence at that point, right? Now, if I'm having a private conversation in my home, right, I have an expectation of privacy there, right? And so that's where people will make that sort of difference or that separation, right? If you're having the conversation out in public, you don't have an expectation of privacy. I have no expectation of privacy within this classroom. Everything that's said in this classroom is really fair game. It's open to the public, right? But if I go home and I badmouth Trump in my house, right? Do I have an expectation of privacy there? Yes. If I badmouth Trump in front of a class and it offends somebody, do they have a right to be upset at that point? Yes. Right? It's just a difference. Right? If you've been upset because I badmouthed Trump, just realize I badmouth all politicians, not just the ones you love. I hate them all. All right. So here's the deal. When you look at sort of the history of judicial activism versus judicial restraint, you'll actually learn that originally the court being too activist was striking down all sorts of laws as they pertained to the New Deal, right? And because FDR was dealing with an activist court, that's why he tried to pack the court with people that bought into his ideologies, which ultimately led to them maintaining 9 members on the court, but sort of swinging their ideologies or their philosophies a little bit to be more in line with public perception, right? And public opinion and what the government and what the people want. I would make an argument that this is actually the opposite of judicial activism. This is actually judicial restraint. That's what they're doing. But generally when it goes against you, regardless of the side that you're on, when the court is doing things that you're opposed to ideologically, you think the court is an activist court, right? So you end up with that changing with the Warren Court. There were complaints that the Warren Court was too much of an activist court, because it was making rulings right, like the Miranda warnings, that was seen as being too activist, that people didn't need to know their rights, that basically if you were not aware of your rights, that's your own stupidity and your own fault. And on some level, that's probably an accurate statement, right? On some level, you should probably be made aware of your rights prior to being arrested, because I'm going to go ahead and assume nobody in this room has been arrested. Maybe I shouldn't make that assumption, but I will for the moment. It can sort of be very off-putting, and because it sort of takes you by surprise, you might actually forget things that you already knew, in which case you might need a reminder that, hey, you don't have to answer questions right now, all right? So by the 50s and 60s, the Warren Court were talking about it being activist. The Berger Court is considered activist. The funny thing is we now get back to what's been a fairly conservative court, and you have individuals now talking about us having an activist conservative court, because they are creating sort of precedents. You might have heard things like corporations are people. Have you heard that term? No? Blank stares. What is the Citizens United decision
Where is this not Protect Corporation?
versus FEC, the Federal Election Commission?
Oh, that was about, I did that.
You did that one for
It
the
was
SCOTUS
like something, it
assignment.
had something to do with like the Hillary movie and like the funding they used for it.
Yes, it has to do with campaign funding, basically. Okay? And the court decided that under freedom of speech laws, right, you can't actually limit the amount of money in campaigns. Right? Now, do you and I have freedom of speech? Yes. Does Chevron have freedom of speech? Does it?
Yeah.
So you're telling me that a corporation is a human being?
It's led by a bunch of human beings.
The individual human beings do have freedom of speech, right? Let's say, for the sake of argument, then, can we? What was it? It was BP, right? Wasn't that Event Horizon or Deepwater Horizon? Deepwater Horizon was BP, right? So can we put BP on trial for murder? Did British Petroleum kill 6 guys, or how many died in that fire? Because if you're going to tell me that it's a person that has freedom of speech, then it's probably a person that can be put on trial for murder. Yes.
You can do the person in charge. Like usually, whenever they're like a corporation issues those statements, it's like usually the CEO or somebody that.
So again, then a person has freedom of speech, and a person can be tried for murder. But you understand how then liberals are complaining that that's an activist approach. Do you get that concept? And I'm not trying to sway your opinion one way or the other as to whether or not corporations should have freedom of speech laws or anything like that. I'm simply giving you the argument that the liberals give to show that this is judicial activism from a conservative standpoint. Make sense?
Because
Okay.
like that Uber CEO, like he came out and said something about Trump or whatever, and then like the media made that as Uber's philosophy or whatever.
Say what now?
Like whenever the CEO of Uber said, like he said something about like, I don't know what it was, it's like about Trump or something.
I have no idea. I know it's like your generation's all the
Or
rage
like even
about
with Starbucks, like the CEO like said something about hiring all those immigrants.
Oh my word! Do we really need to have this conversation again? The CEO of Starbucks said that they wanted to hire 10,000 refugees, and Americans freaked out and were like, "Why would you hire 10,000 veterans?" They already did. They had a program in place to hire 10,000 veterans that started like 4 years ago. They're at like 9,200. They've almost met their goal.
Well, like I'm saying, like when the CEO comes out and says that, they make that into the company's stance on things.
Sure, but companies have sort of unlimited. Well, they have far more resources than what individuals have, right? Plus, think about it in this regard in terms of like companies. Because I assure you, you probably have people that work for Starbucks that were like, no, dude, I'm not in favor of this. Shut your mouth. right? But now, as a Starbucks employee, they're being represented by that, and that's their speech. Is that really their speech? Right? Which means maybe we don't want companies to have freedom of speech. I'm just saying maybe, right? All right. So
Wait, companies have freedom of speech if I can go to the cake, the cake deal where I go to somebody and then the company can refuse to bake me a cake. So that's,
Well, they actually
that's
can't.
freedom of speech.
in most instances they can't. Now that's actually deemed to be discrimination, right? They can't look at you and be like, sorry, we don't bake cakes for redheaded people, right? Like they can't do that.
I mean, if it's for religious reasons, they can't, right?
No.
Like if it's making for like a gay wedding or something.
No. There have actually been instances where they try to make like a bakery bake a cake for a gay wedding, even though they're adamantly opposed to it because they're religious, which I find to be just absolutely asinine. Because if somebody doesn't want to make your wedding cake, why would you force them to do it?
So
Do you really think that cake is going to taste
Well,
good?
if you don't.
I would intentionally make the crappiest cake in the world.
And if you take your business elsewhere to a place that does sell your cake or whatever, that company may go out of business in a capitalist system.
Exactly, it should go out of business in the capitalist system. Right? I'm going to tell you right now, if any one of you comes to me and you're like, hey, I went to ABC Bakery and they said that they don't serve my kind, I'm going to look and be like, what do they mean when they said your kind? And if Zane's like, they called me a ginger, I'm going to be like, all right, dude, we need to go boycott that place. Let's start a little campaign and be like, stop hating on the gingers. Okay? Right? I'm obviously not redheaded, but I would support Zane in that. Right? Regardless of what, like if they said that they didn't serve Ashley because she's a female. Right? I'm not a woman, but I'm not okay with that. Right? And in a capitalist system, theoretically that would take care of itself.
So has there been a court decision on that?
The actual Supreme Court, not to my knowledge. The Supreme Court, to my knowledge, has not ruled yet, and it wouldn't at this point under a court of 8 anyways, because I'm going to tell you right now, it's going to come up 4-4.
Yeah.
I'd be 100% honest with you. Somebody, and I'll use Scalia as the example because if you haven't figured out yet, I'm a fairly big fan of Scalia's. Right? I love his intelligence. But I would assume that Scalia actually wouldn't take a case of that nature anyways, because he would view it as lacking any sort of federal standing. It's not a federal case, right? And my guess is Scalia might, this is a guess now, I'm not as certain about this, but my guess would be that Scalia might be the type of judge that would look at it and be like, if Alabama wants to have a law that says for religious reasons you don't have to bake the cake, then okay. And if California wants to have a law that says you can't deny somebody services based on A, B, C, D, and E, then okay.
That would be saying that a company is not a person then, because that would be taking away their freedom of speech.
It would, and I don't think
So
companies
that would differ from the
well, yeah, because he was,
corporations or people, or the other case that we were just on.
yeah, Citizens United, he was on the side of corporations being people, so maybe I'm wrong. Alright?
But if that's the precedent, then that would affect, if it says corporations are people, then that would affect.
It would, but the precedent in that regard is not always, it's not always upheld. They sometimes find ways around sort of that aspect of a precedent, because they'll make slight differences in the legal argument. All right. But so this basically goes through, because we're pretty much out of time, aren't we?
Yeah, we got that too.
Okay. So essentially, this is just the end here of everything on the judicial branch in terms of how this has sort of played out over time. The ideas of restraints, we don't sort of overturn we don't overturn other case law very easily. So whatever happens, happens. And then as far as the public opinion goes, for the most part, the court doesn't follow public opinion. I know that the juniors saw a little bit of this yesterday. I don't know how well you paid attention. But this should give you an idea about, This should give you an idea about how some judges make decisions in regards to judicial restraint.
Is that somebody has to win and somebody has to lose. You make half the people unhappy 100% of the time. That's the job description.
It'll come up here in 1 second.
Larger than yourself, that you're part of something larger than yourself. And I believe in the rule of law in this country. And I believe in an independent judiciary is one of the keys to it. And I feel it has been a calling to be a part of that. And
Coach Baker, you see that statement by
Well, the Fourth Amendment
Chuck Schumer?
protects the right to be free from, quote, unreasonable
Pay attention to this.
searches and seizures, unquote. It was written in the late 18th century when the tools used by law enforcement to investigate crime and monitor suspects were radically different than they are today. In your view, how should a judge approach
All right, well,
apply